Hey everyone, what's up? Big day for me. Welcome to North America Show. I'm having a good day. It's one of the best days I've had in a long time. It is fantastic, and I'm glad to share it with you all. The reason it's a good day is because I get to smack around arrogant lefties again. So that's always a good day when you get to do that. But no, in all seriousness, I finally bought my lawnmower today. It's a bad boy, 54-inch deck, zero turn mower. I finally got it. And I'm very pleased I got to mow my yard with it for the first time. Now, I did not buy the bagger. I'm going to eventually get the bagger so that it gets all the mulch, all the grass clippings up. But man, it feels great. So, still got push mowing to do. So, I have like less than an acre, but there's a lot of bushes, trees, stuff like that, roots that come up. So, I don't want to run the zero turnover it. So, I got some weed eating and push mowing to do tomorrow. But man, it feels nice to finally have a mower. I'd been going through this thing where I bought a riding mower like secondhand, and then I'd have it work for 3 months, and I'd have problems, and buy another. So I got like three riding mowers in the past 3 years. And before I herniated my disc in my back, I would just push mow it, and it would take me a decent amount of time. But I just said, "The heck with it. That's what I'll do." But since I've hurt my back, it's difficult for me to get out and push mow like that. So it's nice. It's nice to get something that I'll be able to do the yard work. It's super chance paid off. Yeah. Now I didn't make. I said if I made 3,000 in a month, I didn't do that, but I'd been saving enough that, thanks to Trump's economy, I was able to afford. Finally, things are looking up for me. So it was very fun. Uh, Now I will say this: do you ever watch a movie and someone's piloting some sort of vehicle and you assume like, I could do that. Like I've never had illusions that I could like ride dirt bikes like people you see in the movies or motorcycles were doing crazy stunts and stuff like that. But I'd watch a movie and see them like fly an airplane and be like, yeah, I could do that. I I can handle the like you push that little handle thing up and it accelerates a little, and then you got this thing, or even the old timey movies with like the biplanes where they just have the joystick. I'm like, yeah, man. I assume I played Ace Combat back in the day. I could do that. You know, this was the first time I was ever on a zero turn mower ever, and I have to say it has completely erased uh, the idea that I think that I could like hop behind an airplane or something and pilot, because this running like this system, like I got the hang of it, but it took like 20 minutes before I like could really understand. It's just wasn't intuitive to me, right? And so both handles forward to go forward, both back to go straight backwards, but then left, right, turns like that and what have. Now I know everyone's probably laughing, like I picked it up right away. Maybe I'm an idiot. That's but no wrecks or anything. I didn't bump into anything. I had a little trouble getting it off the um trailer that I had it on, but that's because the reason I had trouble was we needed to adjust the arms to right where I needed them. For some reason, the default that they had were like this. So one was like a good 2 inches ahead of the other. So when I brought them back to the same like position, it actually was off tilter. So yeah, that's why pilots say you won't see me wrecking a helicopter into an airplane. You won't see that. I understand. So thank you all for those super chats. Mucho appreciated. Thank you, especially to my wife, for letting me make a bigger purchase like that. It's amazing to have a wife that supports me and is a fantastic mom. I can't speak highly enough of my wife. She's just the best person in my life, her and my son. And you know, I tell her all the time, I'm constantly like needling her. I'll tell you another story here some other day about the show The Pit that we watched. It's sort of like a hospital dramatization, except it's like sort of like the concept of the show 24 Hours was, where it's in an emergency room and each episode's like 1 hour. So one season is like one day in the emergency room in Pittsburgh. Super woke. There's a bunch of woke garbage. But I'm watching this show. My son went and stayed with his grandparents for one day last week, and so we were like, hey, we could watch a show that's not Mickey Mouse or the Minions, so we turned on this show and watched 4 or 5 episodes of it, and I just constantly, my default settings just to constantly mess with my wife. So like she's into this show and I'll just be like, we need 50 cc's of clobbertrol stat. I told you to get on that. And she's like, would you just shut up? You're such an idiot. And then, there's super lefty stuff. Like this one doctor convinces that this girl wants an abortion, but she's like only 17. So she needs the mom to sign off. And the mom's like, no abortion, it's murder. And then I'm going to spoilers for the show, The Pit. I haven't seen how it ends, but I could guess the season. Right. And so this woman doctor like goes up to the mom's like, you're going to lose your daughter if you don't allow her to have this abortion. And I'm just like, And then it turns out that woman doctor that said that is pregnant. And it looks like it's going down the path. I haven't got this far yet, but it looks like she's going to have a miscarriage. And I'm like, that's karma. You killed that other baby. Now they're coming for yours. My wife's like, could you just shut up? Could you just enjoy the show? So for someone who constantly needles her, she supports me in everything I do. And so have I watched The Newsroom? No, I'm aware of it. I've seen clips, but I never watched it. How big of a yard do I have? It's close to an acre. I think it's probably in between 3/4 and an acre. So it's not a huge yard or anything like that, and it's relatively flat, which is nice. I have a problem with moles, though. I've had this 3-year battle with moles in my yard. They're digging holes in my yard, and I set traps, and they don't seem to be working. And then last year, I didn't have a big mole problem because they sort of migrated to my neighbor's yard, and now I'm seeing holes again. So I think the moles are back. So the battle will commence. Me and my yard problems, but now I have the aid of a a bad boy 0-turn mower. So I'm pumped, and all good stuff. So today we're going to talk about something that probably no one's interested in: my battle with Pisco. Whee! There's other things to talk about, but I was busy all day. And I wanted to talk about this. It's sort of illustrative. I talk about this a lot. Oftentimes in the debates that I get in, I find the meta conversation more interesting than the overarching conversation, because a lot of times the meta conversation can give you an insight into the type of people you're arguing against and sort of the tactics, beliefs, and whether or not they're arguing in good faith, etc. And for me, sometimes I find that more interesting, because one of the things that I firmly believe is most of these people that criticize things about Trump, like regarding lawfare, things of that nature, they don't care at all about that. They're totally willing to throw those rules out the book if it means getting Trump, because Orange Man bad. They wanted, for example, large amounts of illegal immigration. And so they'll pretend that they wanted the border secure. And then, when it comes to election season, and then say, oh, but you can't deport anyone and it'll take years and years, etc. So the meta conversation oftentimes gives insight into sort of the way people argue, and it allows you to consider whether or not you should take people's arguments seriously as people that are advocating in sort of a good faith, or if they're just sort of debate bro, big manning it. And Pisco is certainly that. Now, we've gone through many examples showing Pisco, who I like arguing with, because even though I think that he's either consciously or unconsciously bad faith, I don't know which one, it hardly matters. It's still, he gets into the meta of issues that I like talking about. And I like that. I also have no ill will towards Pisco, a person. I hope he thrives and does well. There are people in this space that I think I enjoy debating. Some of them I don't really care for as people at all. Pisco's not my friend or anything of that nature, but I don't think he's a bad person. I don't wish him any ill. I welcome his success on this space and whatever other endeavors he has. I hope that he gets married and has a beautiful family, and figures out once he has kids that he should be Republican, and not even Republican, populist, we'll say that. But nonetheless, that's it. So I could separate my political arguments and people that I think are arguing in bad faith ways, etc., with my feelings of them as like an individual and personal desire to see them do poorly or anything. I don't have any of that. So, with the history of Pisco, we could see from back to the Jabal Bowman thing. Quick rundown of that. He had said repeatedly that lying to law enforcement materially about a case is something, well, when Trump's team did it, we absolutely have to press charges. It's very important. Then he also admitted that there's no way that Bowman didn't know that alarm was going to go off when he pulled it. And then we saw from the released documents from his interview or discussion with law enforcement, when he was asked, did you intend for the alarm to go off? He said no. And Pisco said, well, maybe that's not a lie, because maybe I think what he meant was, when he said, no, I didn't intend for the alarm to go off, what he really meant was, yes, I did intend for this local alarm to go off, but not the global alarm. That's right. I'm extending an olive branch to Pisco so he doesn't put me on notice. That's it. Then there was the Martha's Vineyard, where, the NIMBY situation, where around 50 illegals ended up in Martha's Vineyard, and boy, oh boy, they can only handle it for 48 hours. And Pisco said, well, maybe they didn't have the financial resources. One of the wealthiest communities in the country, they didn't have the resources. My county, on the other hand, I think, I don't know what it is, like 34,000 is the average like household income or something like that. I don't know. We're pretty poor. I will guarantee you, if 50 people got stranded here, we could handle it for more than 48 hours. We'd give them a little more than Fruit Loops and yell Miyama on the way out the door as the National Guard ushered them off to some military base. But Pisco, he defended that, right? Then there was you're right. That Luis Vasquez says no. When Biden said that Trump supporters, the only garbage he sees are Trump supporters, there was an apostrophe. There was trust me, there was an apostrophe. Biden's not calling Trump supporters garbage. That was a good one. There was it was bad that the got illegal FISA warrants to spy on the president. It was regrettable. It was regrettable. What can you do? Anyways, moving forward. So you see a lot of these sort of behaviors from Pisco, but this one I especially like that we're going to talk about today. And the reason is because he's appealing to authority of him being a lawyer, and he's appealing to he makes this sort of ridiculous point, like guffawing, trying to argue this semantical point. And then it turns out, upon delving into it, he's not even right about the semantical point. And so what he does is he doubles down over and over and over again, like, well, I'm a lawyer and you're not. You're such an idiot. Now, the overarching point that he made is sort of nonsensical in the first place. It's just designed to be slippery and try to obfuscate like he often does. But we'll delve deeper into this. So we talked about this briefly. By the way, I think it's funny too. Pisco's like, oh, Rob's doing his third Cope stream tonight. So far, I've talked about this. I talked about it like maybe 20 minutes yesterday and like 10 to 15 minutes the first day. Pisco's done. Every time I talk about it, he does like a 2-hour show on it. On my 10, 15, 20 minutes. So good. So what I'm going to do for you is I'm going to play a clip. Now, what we're talking about here is Garcia, this guy that was deported. And the specific part in the spaces that we're talking, I mentioned that, listen, basically the Trump administration knew that they didn't have jurisdiction. Boasberg didn't have jurisdiction. So they're not going to turn the planes around in mid-flight. And Pisco jumps all over. No, that's not true. The Supreme Court didn't say that Boasberg didn't have jurisdiction. He didn't say that. Right? So that's where we're going to start. And this conversation happened 2 days ago, 3 days ago, 3 days ago. So we're going to start there. Let me make sure I get the right spot. Okay. If I can figure out, Boomer, I'm trying to figure out how to share screen here. We'll get it. I'm all excited. I got my 0 turn. So All right. You ready?
You think Boasberg is some Democrat hack?
Well, I think that we can see that through the history of the Kleinsmith thing, and now through a pattern of claiming jurisdiction when he blatantly didn't have it when it came.
So he absolutely had subject matter jurisdiction. He didn't have venue. He had jurisdiction. And the courts have confirmed, by the way, that the Supreme Court has confirmed, for example, in the Kilmar Garcia case, that the courts have jurisdiction over that case. And so it just isn't the case. I mean, they've lost in the jurisdiction.
Now, I want you to go back and see what I said. You can see sort of the transcript on the right here, which is basically correct. I said the Kleinsmith thing, and now through a pattern of claiming jurisdiction when he blatantly didn't have it. He says, no. He absolutely had subject matter jurisdiction. See what he does there? So I claim the court said he didn't have jurisdiction, and Pisco says, no. He had subject matter jurisdiction. He completely changes what I said. Now, in order to have jurisdiction, you need to have personal jurisdiction. You need to have subject matter jurisdiction. You need to have territorial jurisdiction, and there's other types of jurisdiction. If you don't have one of those, you don't have jurisdiction. We'll get into that in a minute. But notice that's the core of his strategy here. To make it sound like what I said is inaccurate, and then change what I say, change the language. So let's keep going with this.
Jurisdictional cases.
Explain to me the difference between venue and jurisdiction.
Yeah, sure. Jurisdiction relates to whether or not the court itself is empowered to hear those kinds of claims, right?
Whether or not the court itself is empowered to hear these claims. I would say the scope of the court to have authority to rule over, to litigate a case or to judge a case that's being litigated. But
So
whatever.
subject matter jurisdiction is different than like statutory venue, which is basically in which of the many of this type of court you have to bring it. So in the context, for example, of civil litigation, there's the venue statute, which says, you know, even though other courts might have subject matter jurisdiction. So for example, federal courts generally have subject matter jurisdiction over cases that rise in diversity jurisdiction, or that raise federal issues. Notwithstanding the fact that the federal courts have subject matter jurisdiction in those areas, the statute on venue tells you that there's a preference order for where you're supposed to bring those cases.
So he's talking about sort of civil cases and diversity jurisdiction. That's not what we're talking about with this case. But he's saying, well, there's a preference in where you're supposed to bring those cases. And so venue is not the same as jurisdiction. We'll get to here in a second.
And for habeas matters, the venue statute specifies that it's in the place of incarceration. And then there's
So for habeas, the venue statute says venue is in the place of incarceration or confinement.
additional holding from the Supreme Court, which is that any case involving the determination of an Alien Enemies Act can't be brought under the Administrative Procedures Act. It has to be brought under the habeas petitions, and therefore
the Supreme Court also said that you can't bring it under the Administration Procedures Act. It has to be brought under the habeas.
where the venue was improper, but that doesn't relate to subject matter jurisdiction as
so the venue's improper, but that doesn't relate to subject matter jurisdiction. See how he did that again? I said Boasberg didn't have jurisdiction, and both times he says he had subject matter jurisdiction, so you're wrong. Right, but if he didn't have territorial jurisdiction, then he didn't have jurisdiction.
Boasberg laid out in his opinion.
So that's a lengthy explanation. Now, we went over some of this yesterday, so we don't need to rehash it, but there you go. That's where we stood. Now, yesterday, I brought up this. Because when I was doing that Spaces, the idea was, I don't blame Pisco for this, but this is the idea. This happens all the time. He said, hey, call in for a second. Just call in for a quick second so we could discuss the modern day debate thing, why we didn't have this debate on Friday. Okay. And then we ended up going for an hour and a half or so, 2 hours about things. I wasn't in front of a computer. I sound like I have a lisp because I'm on my phone talking to him on his Spaces, because my phone sounds like I have a lisp when I'm talking on Spaces. Yeah, enemy says, yeah, this is inequivalent. I say I'm wearing a shirt. Pisco says, you aren't wearing a polo shirt. I say, that's not what I said. I said I'm wearing a shirt. Pisco, effing moron Rob doesn't know what a polo is. LOL owned. Yeah, that's basically what's going on. So I brought this up yesterday on the show. I said, look at this. When I actually bring up the hearing or the Supreme Court ruling, this is what it says. For corp habeas petitions, jurisdiction, notice that word, jurisdiction, lies in only one district, the District of Confinement. In other words, if you're dealing with habeas, the only court that has jurisdiction is the District of Confinement. All other districts wouldn't have jurisdiction. That's from the case Rumsfeld v. Padilla. Then it goes on. The detainees are confined in Texas, so venue is improper in the District of Columbia. As a result, the government is likely to succeed on the merits of this action. And they suspended the TRO. That's where we stand as of yesterday. Now, we have interactions on X, which we'll get to. And then we'll delve deeper into this issue. First, Pisco was busy or whatever, couldn't call in. That's no problem. I offered, I said, you want to call in? As soon as the show ended, I saw Pisco was like, Rob's doing a cope stream. He's coping, blah, blah, blah. I said, you want to call in and discuss it? He says, nah, I'll do a stream about it tonight. After I tell my audience how you're wrong, you could call in. I don't know what time Pisco started to stream, but the nature of my work schedule was I had to be not streaming by at least 9:30. And I don't think Pisco was streaming by 9:30. So I was done streaming. That was it. I had 10 minutes to give him. That's it. Other than that, okay, no big deal. Of course, many of Pisco's followers are like, Rob's a coward. He didn't join Pisco's stream at like 1 a.m. So even if I wasn't working, dude, I'm not obligated. If I say, sure, I could talk about this now, and you say, no, I'm going to talk about it in my stream at like 1 a.m. And after I tell my audience how you're wrong, then you could call in. Yeah, I'm not going to do that most nights unless I happen to have free time and I'm bored. But I think it's funny that his fans think that I'm a coward for not calling into his stream, but Pisco's not as coward for being busy and being unable to talk to me when I said, hey, you want to talk about it? I think it's probably reasonable to think neither of us are cowards if we're operating on our own time frame. So I don't know what that sort of is about. But let's just dive into sort of what Pisco says. He said it was my third Cope stream. Just to be clear, the Supreme Court did not rule Boasberg lacked jurisdiction. Rob Noor is confusing venue and jurisdiction and the habeas statute, which references territorial jurisdiction, as explained by Kennedy in the Padilla decision. And he links a couple things. We'll get to these things he linked later. Because I said, I watched the relevant parts of Pisco's Cope stream. Spoiler alert, he's wrong. The Supreme Court did rule Boasberg didn't have jurisdiction. Him trying to weasel out of this is laughable and indicative of how bad faith he is. I'll be covering it in tonight's stream. So he says, the court didn't rule Boasberg lacked jurisdiction. It referenced the habeas statute, which references territorial jurisdiction. I said, territorial what? He says, territorial jurisdiction is in geography over which the court sits, dipshit. It's a venue rule, not a jurisdictional rule. Hence the explanation in Padilla. I highlight the word jurisdiction. I say, thanks for playing. Now, his whole argument is, I was incorrect. I played the clip when I said Boasberg didn't have jurisdiction. He said, yes, he did. Yes, that's ridiculous. Yes, he did. He absolutely had jurisdiction. He had subject matter jurisdiction, he says. Well, that's not just because you have one type of jurisdiction, you need all types of them. Let me give you an example. If you have territorial jurisdiction, let's say you're a small claims court, right? And you have personal or territorial jurisdiction, right? So I'm Rob. I live in this county I'm in Pennsylvania. The county court has personal jurisdiction over me. But if they don't have subject matter jurisdiction, so the small claims court in this county doesn't have jurisdiction to hear my case about a murder that I committed, do they have jurisdiction over me? Regarding that particular case? No, because they need to have the subject matter jurisdiction, the personal jurisdiction, territorial jurisdiction. If a court has subject jurisdiction, for example, if Boasberg in the DC Circuit has subject jurisdiction over habeas actions with people being deported under the Alien Enemies Act, does that mean they have subject jurisdiction, or they have jurisdiction over a person who's never been in the United States? I guess it's not a good example because the Alien Enemy Act would probably be only enforced on people that had been in the United States. But if they have subject matter jurisdiction over, say, people that improperly pay taxes, and here's some dude that didn't pay his taxes to the government of Australia, just because they have subject matter jurisdiction over improper payment of taxes doesn't mean they have jurisdiction over this guy, because they don't have territorial jurisdiction or personal jurisdiction. Now, I'm making this more complicated than need be. We'll get to it in a second. Again, the key point here is Pisco is using the term jurisdiction synonymously with subject matter jurisdiction. When I say Boasberg didn't have jurisdiction, he's like, oh, Rob's saying Boasberg didn't have subject matter jurisdiction. That's not what I'm saying. Now, I think in order to further delve into this, we should first ask ourselves, what is the meaning of the word jurisdiction? That seems to be the argument. The argument isn't what is subject matter jurisdiction, it is what is jurisdiction. Now, as a layman, I would say jurisdiction in general is the areas that you have power over, the scope that you have power. So areas as in geographically, but also in areas subject-wise. So, for example, a police officer can have jurisdiction, right? In talking about courts and judges specifically, you would say areas both geographically and subject-wise that they have authority over to make judgments about. Their power over. That's jurisdiction. That's how I looked at it. Does anyone disagree? Does anyone want to give me, and of course, Pisco didn't give me the definition of what jurisdiction is, other than he said, let's see, he said that I say, what's the term jurisdiction mean? He doesn't say specifically. He says it's got different contexts. So there's personal jurisdiction and there's subject matter jurisdiction. There's different kinds. What does the word jurisdiction mean? It usually implies some at a broad level, some kind of power over a thing. Power over a thing, jurisdiction. Did Boasberg have power over the thing in the sense that his temporary restraining order was allowed to stand against the Trump Justice Department? No, he didn't. His restraining order was revoked. Why? He didn't have the power to issue it. But let's go to a more definitive explanation. Cornell law. Jurisdiction can be defined as 1, the power of a court to adjudicate cases and issue orders, or the territory within a court or government agency that may properly exercise its power. So either of these we could take, but let's take the first one. The power of a court to adjudicate cases and issue orders. Boasberg issued an order. He issued a temporary restraining order. The Supreme Court said that TRO is not in effect because you don't have the power to issue it. Pisco says, but that wasn't because of jurisdiction, it was because of venue. But if the order that he ordered is ruled by a higher court to not be in effect, not being allowed because he didn't have the ability to order it because of venue, if the word's going to be that we use, or because of jurisdiction, doesn't that imply that he didn't have the power to adjudicate the case and issue orders? He may, in theory, have subject matter jurisdiction, and yet still, with being allowed to have subject matter jurisdiction, his order was overturned because he did not have jurisdiction. Let's continue. One of the most fundamental questions of law is whether a given court has jurisdiction to preside over a given case. A jurisdictional question may be broken down into 3 components. Now, when it says here, one of the fundamental questions is whether the court has jurisdiction to preside over a given case. The court said, no. The Supreme Court said Boasberg did not have jurisdiction to provide over the Garcia case and these people on these flights. He did not have jurisdiction. Was he allowed to preside over that case? No. They said the remedy for those people was to file habeas, and because they were detained in Texas, that's where the habeas had to occur. Does anyone disagree that that's what's occurring? Now let's steelman Pisco's argument here for a second. No. The courts didn't say that he didn't have jurisdiction. They said that it was the improper venue. Nonetheless, if that's their argument, just subbing out the word venue for jurisdiction still means the court didn't have the ability to preside over this given case, the jurisdiction. That's why, what's that mean? The power to adjudicate the case or issue order. They did not have that power. Why? Pisco says because of venue. My argument is yes, thus proving it was a jurisdiction. They did not have jurisdiction. Let's continue. Whether there's three parts, whether there is personal jurisdiction, aka whether the court may even hear the case involving particular defendants. This is further broken down into three categories: in personam, in rem, and quasi in rem. Second, so there's personal jurisdiction. Second, jurisdiction over subject matter. That's one of the three. Now, again, this is what Pisco's going to hang his hat on. When I say Boasberg didn't have jurisdiction, he says, no, the courts didn't say he didn't have jurisdiction. He had subject matter jurisdiction. But that's only part of having jurisdiction. By the way, I missed a super chat. Thanks so much, Corey Barton. Says, for $2, think Pisco's slimy, then try out our new big slime soda. Thank you. The third type of jurisdiction, whether there is jurisdiction to render the particular judgment sought. The term jurisdiction can best be understood by being compared to power. Any court possesses jurisdiction over matters only to the extent granted by the Constitution and or legislation of sovereignty on behalf of which it functions. For example, the state court of Mississippi may need statutory permission by the Mississippi legislature to hear certain types of cases. The question of whether a given court has the power to determine a jurisdictional question is itself a jurisdictional question. Such a legal question is referred to as jurisdiction to determine jurisdiction. Subject matter jurisdiction is the court's authority to decide the issue in controversy, such as contracts issue or a civil rights issue. State courts have general jurisdiction, blah, blah, blah. Read this next paragraph. Territorial jurisdiction is the court's power to bind the parties to the action. This law determines the scope of federal and state court powers. State court territorial jurisdiction is determined by the Due Process Clause of the 14th Amendment, and the federal court territorial jurisdiction is determined by the Due Process of the 5th Amendment. Other forms of jurisdiction include appellate, concurrent, diversity. So it specifically references territorial jurisdiction. What is territorial jurisdiction? Let's go to the same. Source. Territorial jurisdiction is a court's authority to preside over legal proceedings in a geographical area. Let me read that again. The court's authority to preside over legal proceedings in a geographical area. Now, note it doesn't say territorial venue. It says territorial jurisdiction. In other words, there are geographic areas that certain courts would not have jurisdiction over. It continues, territorial jurisdiction is the scope of a federal and state court's power and is determined by the governing laws and regulations of the area. Factors that are often considered when granting a court territorial jurisdiction over a case include where the cause of action took place, the residency of the parties involved, or the nature of the dispute. State court territorial jurisdiction is determined by Due Process Clause. Typically, state courts have territorial jurisdiction over states' residents. Federal court territorial jurisdictions, the Due Process Clause of the Fifth Amendment. Federal courts have jurisdiction over federal questions and or statutes. For example, federal court has territorial authority over a criminal case involving a federal crime. Is there anyone out there that thinks that there's not a thing, that territorial jurisdiction isn't jurisdiction? Davo says, why is Rob dodging Pisco? He invited him to talk it out on stream. I invited to have Pisco come on and talk to me. He said he was unwilling to do so and said, no, I'm going to talk to my audience and then stream, and then you could come on. Pisco is invited to come on my stream right now if he would like. Absolutely. I have no problem with that. I had obligations for work that I couldn't stay up until he started streaming at midnight. That is exactly what happened, Davo. You explain to me what happened. You tell me what happened. You tell me. Now, again, I just want to be clear. This is the caliber of the people we're dealing with. This is the caliber of the people. He never said no. That's not true. He did. Absolute lies. He didn't use the word no, but I set the offer out, and he said, nah, I'm going to be streaming it tonight. You can come on then. Happy to have you. Hop on right now for 10 minutes to discuss it. I didn't say you only have 10 minutes. I said it'll take 10 minutes to discuss it. He says, we'll be reviewing your stream, Rob, and providing the critical analysis it deserves and blowing you the hell out for your ignorance. And then happy to have you on. I said, no thanks. Won't be around. Happy to talk to you now if you like. What time did Pisco stream last night? It does sound like a no. Do you want to stream now? And his response wasn't yes. It was, I'm going to be talking about it later tonight, and then you could talk to me after I talk about it. What time did Pisco stream last night? Just curious. This says started to stream 23 hours ago, so that would mean 10:49? Yeah. He offered to let you on his stream. Notice, by the way, his condition wasn't, sure, let's talk about it. His condition was only after I prime my audience and say what I want, then you could come on my stream to talk about it. Doesn't matter if it was midnight. I said I didn't know the time he was talking. I'm not obligated to stay up to a time like midnight. Davo, would you like to call in? If not, I'm just going to ban you. I don't have time for trolls like this. It's silly. I'll just keep getting distracted. It's my fault, not yours. It's just it's silly. It's absolute silly. I offered to talk to him. He was like, nah, I'll be talking about it tonight. I was like, I can't join tonight. I have other things to do. That's it. If you'd like to call in and discuss it, you could absolutely call in. If you don't want to call in, then we're going to let you go. We'll give you 5 minutes to say you're going to call in, and then we're going to let you go. So my condition wasn't that I must talk within the next 10 minutes. I said, do you want to talk now for 10 minutes? Show me once where I said you must talk in the next 10 minutes. Go ahead. Yeah, we'll see it. Oops, sorry. So we've looked at territorial jurisdiction. One more thing before we get to the clips. Personal jurisdiction. Remember when it said jurisdiction, it said you have personal jurisdiction, which broke into 3 parts. Then you have subject matter jurisdiction. So what is personal jurisdiction? Personal jurisdiction refers to the power that a court has to make a decision regarding the party being sued in a case. Before a court can exercise power over a party, the U.S. Constitution requires that the party has certain minimum contacts with the forum in which the court sits. So if the plaintiff sues a defendant, the defendant can object to the suit by arguing the court does not have personal jurisdiction over the defendant. To obtain personal jurisdiction. Typically, for a court to have personal jurisdiction over a defendant, the plaintiff needs to serve the defendant in the state in which the court sits, and the defendant needs to voluntarily appear in court. In other words, part of personal jurisdiction is also discussing location. Dave says he's not going to call in. I'm just a debate bro. Happy to help you. And Dave is one of these people. He's probably that shipwreck guy. He keeps making new accounts over and over again. So even with personal jurisdiction, it's saying, look, a court would lack personal jurisdiction over you if there's not some sort of connection. What type of connections? Well, typically, the plaintiff needs to serve the defendant in the state in which the court sits. In other words, if let's just take someone random in the chat. So if Joe Salt's suing me, and he sues me in the state of California, and I'm like, I've never been to California. I have no businesses in California. The alleged action that you're saying took place in Pennsylvania. How could you sue me? And the court doesn't have personal jurisdiction over me in California because this case has nothing to do with that. Now, the question's quite simple. Given that the definition of jurisdiction is the power to adjudicate case and issue orders, and the Supreme Court said the TRO that Boasberg ordered was not legitimate, it was being revoked because venue, i.e. territorial jurisdiction, it's clear that Boasberg didn't have jurisdiction. One last time before we get to the comments, I remind you what the Supreme Court specifically said. For habeas, because what it's saying before this, it's saying, look, you can't use the APA. Instead, the due process that's afforded to these people being deported is habeas. And habeas, their only jurisdiction is one district, the district of confinement. In other words, where they are being detained, where they're being imprisoned, jailed, whatever. That's it. That's in Texas. They don't get to file in D.C. None of them were being held in D.C. They specifically use the term in their ruling from the Padilla case, jurisdiction lies only in one district, the district of confinement. Why didn't they say venue lies only in one district, the district of confinement? Why do they use the word jurisdiction here instead of venue? Now, Pisco is going to explain why this doesn't mean what it seems to. This doesn't mean that the court's saying they didn't have jurisdiction. Okay? So let's go to Pisco's stream from last night. Now, I didn't watch all of this stream. I watched about 10 to 15 minutes of it. It was a 3.5-hour stream. Sue me. But I think I got the relevant parts here. Notice it's a 20K subs and Rob Noor copes again. So we're just going to start playing it. And what he's doing is watching my stream from yesterday. And there was probably the same guy that this Davo guy, probably the same guy that was on last night, because he's arguing the exact same way, who's probably the guy, the unholy raft person, right, that was in here before, just changing names. This guy last night kept saying, no, it's venue, not jurisdiction. And I kept saying, it blatantly uses the word jurisdiction. Explain to me how that's not the case. Okay? So that's basically where we're starting here. Let's go.
He's citing the case I cited to you, Rumsfeld versus Padilla. All right. So now look at him trying to milk this.
So I'm trying to milk it. I'm citing the case Pisco's citing. We're going to go to that case here in a minute. Jurisdiction lies only in one district, the district of confinement. Let me repeat that. Jurisdiction lies only in one district, the district of confinement. Let me repeat that. Jurisdiction, oops, I lost it, lies in only one district, the district of confinement. Now, John Billy's claiming I'm skipping something. I've skipped nothing. I started reading from the beginning of this. John Billy, would you like to explain to me how that doesn't use the term jurisdiction? Would you like to?
So he is citing the exact case that I just cited and that Boasberg cited that makes a look. This is the case, right? Rumsfeld versus Padilla, where they're acknowledging the fact that this is an abnormal usage of the term. We use it as used in the habeas statute, right? This is why Justice Kennedy goes out of his way in this exact case that the court is citing in the order to explain. Though I join the opinion of the court, this is to state my understanding of how the statute should be interpreted in light of the court's holding. By the way, this is a split decision, and so Kennedy's explanation is the narrowest explanation, and obviously is the one that we should take because of the fact that the footnote 7, which he cited right here, is clearly delineating the jurisdiction as meant by the district court, that is subject matter jurisdiction. So it's a split decision. Kennedy's concurrence here, I think, is instructive in how we should interpret footnote.
That's not necessarily true, but for the sake of this, I'll say that we could accept that here. But theoretically, like what he's saying here is you had 5 judges rule in favor, 4 against, right? But there's a concurrence where Kennedy and I believe one of the other joined the concurrence. They more narrowly tailor it. So they're like, we agree with the 5, but we want to add a little. That's not necessarily the case. I'm not going to get into why we shouldn't always prefer the concurrence, but for the sake of this argument, I'll concede on this. Let's prefer the concurrence, what Justice Kennedy says. Okay.
Note 7. Though I join the opinion of the court, this separate opinion is added to state my understanding of how the statute should be interpreted in light of the court's holding. The court's analysis, that is the Supreme Court, relies on 2 rules. First, the habeas action must be brought against the immediate custodian. Second, when an action is brought in the district court, it must be filed in the district court whose territorial jurisdiction includes the place where the custodian is located.
Pause. It must be filed in the district court whose, what's the word it uses there? Territorial jurisdiction includes the place where the custodian is located. Literally, Kennedy's saying territorial jurisdiction. The court must have territorial jurisdiction, and to have that, it's where the person is confined. Now, listen to what Pisco does here.
These rules, however, are not jurisdictional in the sense of a limitation on subject matter jurisdiction.
Wow, did you see what he did there? Did you see what Kennedy's doing there? Now remember, this entire argument started when I said Boasberg, the court said Boasberg didn't have jurisdiction. And he said, no, they didn't say that. They didn't say that at all. And then what did he immediately do? Immediately. The court said they did have subject matter jurisdiction. Good thing I didn't say they didn't. In order to have jurisdiction, you would need to have subject matter jurisdiction. In addition to personal jurisdiction, which territorial jurisdiction could be part of. If you do not have personal jurisdiction, but you have subject matter jurisdiction, or if you want to separate it and say, if you do not have territorial jurisdiction, but you have subject matter jurisdiction, you don't have jurisdiction. So from the get-go, Pisco's like, oh, when I say the courts didn't, they said that Boasberg didn't have jurisdiction. He's like, no, they didn't say that. They didn't say he didn't have subject matter jurisdiction. And my argument the entire time is like, that's not what I said. I'm wearing a shirt. You're not wearing a polo shirt. Yeah, I never said I'm wearing a polo shirt. Wow. Let's continue. Notice, and we're going to go through this, but notice Kennedy's not saying that it's not jurisdictional. He's saying it's not jurisdictional when it comes to subject matter jurisdiction in that sense. In fact, that sentence alone, these rules, however, are not jurisdictional in the sense of limitation on subject matter jurisdiction. The implication of that sentence is that they are jurisdictional, just not on subject matter jurisdiction. Mr. Ubercross for $20. Thank you so much. An attorney, I believe. The normal rule in SCOTUS opinion is to go with the most narrow opinion. As you stated, a court must have both subject matter, we could do this kind of thing, and personal. We could do this to you, jurisdiction. Correct. So let's continue.
That much is clear.
Let's rewind it a little.
Must be filed in the district court whose territorial jurisdiction includes the place where the custodian is located.
Watch how Pisco's inflection goes here too. These rules, however, are not jurisdictional in the sense of limitation on subject.
These rules, however, are not jurisdictional in the sense of a limitation on subject matter jurisdiction. That much is clear from the many cases in which petitions have been heard on the merits despite their non-compliance with either one or both of the rules. This case proves that my semantics, right, to the extent this is a semantic argument, are normal. These are not.
So he admits that he's just making a bullshit semantic argument. Okay. And he says that it's normal. Well, normal isn't correct. Sure. You could say sometimes when people say you don't have jurisdiction, they're implying that they mean you don't have subject matter jurisdiction. Could be that normally people might think that. That doesn't mean that it's technically correct. He has no evidence that I was talking about subject matter jurisdiction, particularly when the entire conversation up to and after that point revolved around venue.
Not typical usages of the term jurisdictional. And these are not the usages that Rob meant when he used that term.
It is what I meant when I used that term. And certainly when people talk about jurisdiction, normal use is not just talking about only subject matter jurisdiction. Personal jurisdiction, territorial jurisdiction, all of these would be normal vernacular that people are talking about with jurisdiction.
At all.
By the way, previously in this stream, I did see a little part where at the beginning of this stream, I started to talk about, I'm tired of people like Pisco that actually wanted all of these illegal immigrants to come in and they want to make it as difficult. And he goes, Rob's claiming to be a mind reader. Absolutely true. I am claiming that I know what they want without 100% definitive proof. That's fair, right? Pisco has every right to do that to me as well. But he has no proof on this particular issue. One, he's biting the same bullet he's accusing of me. He does this all the time, right? He knows what Trump's mind is. He knows what my mind is. He knows that I was talking about subject matter jurisdiction, even though everything after that was me talking about venue. I didn't have the correct vernacular. I didn't know the term territorial jurisdiction, but it's clear based on my conversation. I'm like, so you mean to tell me that if there's not I'm like, so if the case in California, do they have the right to hear me in Pennsylvania with the small claims? And he's like, well, maybe blah, blah, blah. I guess the way to say that would have been they don't have personal jurisdiction over me. And then there's also this idea of territorial jurisdiction that goes with that. I didn't have those specific terms, but I was right on what my gut feeling was, that a court doesn't have jurisdiction over you if you're in the improper area. It's a geographic location that it doesn't have jurisdiction over. I was correct. So it's clear that I was talking about this type of jurisdiction the entire time. He's just like, no. Now he knows he's blown out. He knows that he's wrong. He absolutely knows. So he's like, well, it's normal to talk like this. And I know Rob met subject matter jurisdiction. Let's go back a little.
Are normal. These are not typical usages of the term jurisdictional. And these are not the usages that Rob meant when he used that term at all. We are referencing the particulars of the habeas statute. And ultimately, it is a rule. What does Justice Kennedy say? In my view, the question of the proper location for a habeas petition is best understood as a question of personal jurisdiction or venue.
Kennedy actually says it's personal jurisdiction or venue. He literally says habeas petition's a question of personal jurisdiction. So the idea that Pisco guffaws like no one would be considering it, literally the opinion you're reading from says it's either personal jurisdiction or venue, the questions of habeas. Now, the word or there's interesting. It doesn't say and. He's basically using those interchangeably, venue or personal jurisdiction. But it's amazing.
This view is more in keeping with the opinion in Braden and its discussions explaining the rules for the proper forum for habeas petitions, indicating the analysis is guided by traditional venue considerations and traditional principles of venue. See also Moore versus Olson, suggesting the territorial jurisdiction rule is a venue rule. And
the territorial jurisdiction rule is a venue rule. Right. So the venue is territorial jurisdiction. Yes. Now, there are times where venue wouldn't go with territorial jurisdiction or personal jurisdiction. For example, there are civil cases where you could say, well, the court has subject matter jurisdiction, but it should be held in this, even though it occurred in this state, the preference should be for it to be held in a venue that's closer to where this took place. So if it occurred in a specific county, the court within that specific county would be the proper venue. But it's clear that this is more than just a venue consideration. It's territorial jurisdiction because they're specifically citing when it comes to habeas, there is only one district with jurisdiction, the district of confinement. So it's clearly a territorial jurisdiction question. As Kennedy's saying here, suggesting that the territorial jurisdiction rule is a venue rule. And the immediate custodian rule is a personal jurisdiction rule. In other words, the area where it's at, the territorial jurisdiction's the venue portion, and the immediate custodian, in fact, that you could only sue the immediate custodian, so the area you're in, has to do with your personal jurisdiction, both territorial jurisdiction and personal jurisdiction. This is from the case that Pisco's reading.
Immediate custodian rule is a personal jurisdiction rule. This approach is consistent with the reference in the statute to the, quote, respective jurisdictions of the district court. As
again, the respective jurisdictions.
As we have noted twice this term, the word jurisdiction is susceptible of different meanings, not all of which refer to the power of a federal court to hear a certain class of cases.
Right. The word jurisdiction can mean more things than just the power of the federal court to hear a certain class of case. Exactly. It means more than just subject matter jurisdiction. It can mean personal jurisdiction. It can mean territorial jurisdiction. So again, for Pisco to say when I said there's not jurisdiction, he's claiming that he knew this case. And so he's like, well, I'm relying on Kennedy's concurrence, which says, well, you could mean all sorts of things by jurisdiction, such as personal jurisdiction, territorial jurisdiction. But he definitively says, no, the court didn't say that they lack jurisdiction.
The phrase respective jurisdictions does establish a territorial restriction on the proper forum for habeas petitions, but does not of necessity establish that the limitation goes to the power of a court to hear the case. Boom, roasted.
Jurisdiction never means venue. The question is, Mr. Ubercross, did the Supreme Court, when they overruled the TRO, because they said the only... Well, I'll show you what they said. They said, for habeas petitions, jurisdiction lies only in one district, the district of confinement. They're detained in Texas, so the venue's improper for D.C. In other words, the only district that would have jurisdiction is Texas, because that's where they're confined. Now, the idea that Pisco says, boom, roasted, when literally he just read the case that shows me, that proves what I'm saying. Over and over, it says, yeah, it's personal jurisdiction, it's territorial jurisdiction, but it's not subject. They're not saying that it lacks subject matter jurisdiction. Now, what's funny about this is Pisco, as he admitted, this was a semantic argument he made. And again, the reason he made this argument was because he's trying to big time to his audience. Oh, I'm a lawyer. You don't even know about subject matter jurisdiction. And he's trying to conflate issues when he knows that, like, basically it's like, yeah, the Supreme Court said his order doesn't stand up because it wasn't proper. He didn't have the authority to make that order. Right. Mr. Ubercrow says one of the venues in Texas might be more appropriate than another. So all the district courts could hear it, but the venue may be proper to a specific court. Right. But the jurisdiction must be in Texas. Now, Pisco just read that, and we're going to go through it as well, and we're going to read it. He reads it where it's like Kennedy's like, well, it's territorial jurisdiction and it's personal jurisdiction, but it's not subject matter jurisdiction. There's still subject matter jurisdiction. He reads that and goes, boom, Rob's blown out, blew him out. And his whole thing is, I'm an attorney. I know that. How embarrassing for Rob. How embarrassing for you. Let's go back just a little.
Petitions, but does not of necessity establish that the limitation goes to the power of a court to hear the case. Boom, roasted. Absolutely destroyed. Kennedy and the court in this very case are noting the distinctive way in which the term jurisdiction is used in the habeas statute. Rob, having never read Padilla in law school, having never referred to Padilla in law school, not understanding the basics of this term, and trying to employ a post hoc analysis, sees the term jurisdiction in this opinion, doesn't read the case at all, where there's this long discussion about what jurisdiction means. Right? There's a long discussion about jurisdiction in this context and what we should take it to mean, and whether or not it's a jurisdictional rule. Doesn't read the Boasberg follow-on opinion after the Supreme Court.
We'll get to the Boasberg opinion. Basically, Boasberg saying, no, it's just venue, not jurisdiction. He's the guy that was just overruled by the Supreme Court, so I hardly care what he says. I'm more concerned with what the Supreme Court said. They cited the Padilla case. Pisco's right. I haven't been in law school. Pisco's right. I never argued the Padilla case in law school. He's implying that he has, and that's why he has better understanding of it. And yet his understanding of it, what he's talking about is jurisdictions used differently when it comes to specific habeas claims. Well, fortunately for me, then, this case was about, drum roll please, specific habeas claims. Well, when it comes to habeas, yes, jurisdiction does mean something different. Great. In that case, when I said that Boasberg lacked jurisdiction, I'm correct. Maybe it wouldn't be the case if this was a civil contract claim. Maybe.
Saying that this is not a jurisdictional issue. Venue was improper.
That's Boasberg's opinion, and he was just overruled by the court.
Citing Rumsfeld versus Padilla. Citing the black letter law that subject matter jurisdictional rules go to whether the courts can hear the dispute. Venue determines which jurisdiction possessing court is the most convenient, and just sees jurisdiction.
Which jurisdiction is the most convenient? But this isn't a matter of convenience. And that's what Mr. Ubercross was saying. Convenience might be every court in Texas has the right to hear this, but it would be more convenient because it's closer. It's held in the county of confinement to hear it here. That's the idea of convenience. This is beyond convenience. The Supreme Court said, no, it has nothing to do with convenience. There is only one jurisdiction which can hear habeas claims. That is the jurisdiction of confinement. That's Texas. So it has nothing to do with convenience. Tainted Oli for $5 says, I'm proud of you, Rob. You're not getting one guide anymore. Awesome improvement. Thank you.
And claims victory. Absolutely blown the fuck out. Now, to take Rob.
Now, again, one of the things you'll notice about Pisco, like when he starts to lose an argument, he'll like up the cursing and he'll like insult, blown the F out. He on X, he was saying, you dipshit, things like that. That's something that he's like. Now listen to what he says here.
Take his analysis, right? He's going to say, well, did the court have jurisdiction or not? Right? That's the question, right?
That is what I'm going to say. Did the court have jurisdiction or not?
A court either has jurisdiction or it doesn't have jurisdiction. Then it, I guess under Rob's understanding of the term, the court both had jurisdiction and did not have jurisdiction. Let me repeat again. The court both had jurisdiction and also did not have jurisdiction. That's where Rob's conclusion would lead you to.
Now, this might be the dumbest thing that he said here. Now, this is supposedly an attorney, right? And Pisco's like, well, Rob's claim that says the court didn't have jurisdiction. Well, if that was true, Rob would have to say that they both have jurisdiction and don't. And I'm guessing that the reason he's implying that is because I'm saying they don't have territorial jurisdiction, but I am agreeing that they had subject matter jurisdiction. So they had jurisdiction with the subject matter, but they didn't have jurisdiction with the territorial. That's literally what every sort of investigation into jurisdiction would look like. For example, if the local civil court in my county has personal jurisdiction over me because I live in the county, but because they're a civil court, they do not have subject matter jurisdiction over criminal offenses such as larceny. Would he say, well, that's odd. How could you believe that? You're saying that they have and do not have jurisdiction simultaneously. Well, yeah, but they don't have jurisdiction because they must have all forms of jurisdiction to have jurisdiction. He's like, well, that's weird. That's weird. For Rob's theory is, if he says they did have one type of jurisdiction, but not the other, well, that would be so weird. That'd be like saying they have jurisdiction and they don't. No, they don't have jurisdiction because they have partial jurisdiction over some of the things necessary to have jurisdiction, but they don't over other things, which means if you need to have all of them to have jurisdiction, they don't have jurisdiction. Why is that so weird?
And by the way, none of this difference in terminology would ever get understood by the relative parties if I didn't speak up, which he takes issue with. He said, of course, it's so obvious what I meant when I said jurisdiction. It's so obvious. But if I had never raised that issue and said it's not jurisdictional, we would live in that contradiction, in Schrodinger's jurisdiction.
There you have it. See, it's a good thing that I decided to just argue semantics, which I was incorrect with, because otherwise we would think that you could have certain types of jurisdiction and not others. The Boasberg case, or writing. First, let's go to Pisco. Pisco cites this part of Boasberg. We'll get to this in a second. Pisco also cites this part of the Padilla concurrence from Kennedy. Okay? Let's go to the Boasberg. Page 21 is where he's at. In holding that habeas is an exclusive remedy for plaintiffs, the Supreme Court denied that they possessed a valid cause of action under the APA when this court granted the class-wide TRO. It did not hold that the court lacked subject matter jurisdiction. See? Court didn't say we didn't have subject matter jurisdiction. In fact, Kavanaugh noted in his concurrence that the availability of habeas relief constitutes an adequate remedy barring suit under the APA. The adequate remedy bar, however, is not a jurisdictional one. On the contrary, the D.C. Circuit has explained that to determine whether there is a cause of action under the APA, not whether there is a federal subject matter jurisdiction. So again, notice that he keeps conflating the word jurisdiction with subject matter jurisdiction. He says the adequate remedy bar is not jurisdictional. Okay, what does he mean by that? He explains. The D.C. Court explained it determines whether there is a cause for action under the APA, not whether there is federal subject matter jurisdiction. So when Boasberg's saying, well, wait a minute, this didn't say I didn't have jurisdiction, he's literally doing the same thing that Pisco's doing. He's saying jurisdiction to me means just subject matter jurisdiction. They didn't say I don't have subject matter jurisdiction. So Pisco just takes it at face value. Well, Boasberg said that he doesn't feel the Supreme Court said he doesn't have jurisdiction. Then he says, under the either habeas or APA precedents, then both paths lead to the same destination. The relevant text in this court's class-wide TRO was not jurisdictional. Again, when he cites proof of it, he says it wasn't a matter of federal subject matter jurisdiction. Then he continues. At worst, the Supreme Court held here that venue was improper in the District of Columbia. Indeed, regardless of how the issue is framed, the court has been clear that any reference to habeas jurisdiction does not refer to the court's subject matter jurisdiction. Rather, the territorial jurisdiction is a question of proper venue. And then he cites Kennedy, the concurrent, which is where Pisco gets to go to Kennedy. And it's black letter law that while subject matter jurisdiction goes to whether any federal court may even hear the dispute, venue determines which jurisdiction possession court is the most convenient. But that's not what's going on. It's not just a matter of convenience. Federal courts can have subject matter jurisdiction but lack territorial jurisdiction or lack personal jurisdiction. Just like the availability of cause of action under RPA, that question has been determined by the statute, the federal habeas statute. Let's go to the concurrence of Kennedy. We'll read the whole thing. It's not that long. Kennedy, with whom Justice Connor joins, concurring. Though I join the court, let me make sure I'm showing you all the, oh, I'm not showing you any of this, sorry. There you go. Though I join the opinion of the court, this separate opinion is added to state my understanding of how the statute should be interpreted in light of the court's holding. The court's analysis relies on two rules. First, the habeas action must be brought against the immediate custodian. If it's not brought against the immediate custodian, what does that mean? If I'm confined in Texas and I have a writ of habeas for Oregon, what happens to that writ of habeas? Oregon doesn't have the jurisdiction to hear it, correct? When you say it must be in the area of confinement, what does that mean? Do courts outside of that area of confinement have jurisdiction to rule on that habeas writ? Yes or no? Of course not. They don't have the jurisdiction to do so. Continuing. Second, when an action is brought in the district court, it must be filed in the district court whose territorial jurisdiction includes the place where the custodian is located. So if you go to a district court, it must be a district court that has the territorial jurisdiction that is the place where the custodian's located. It's not a matter of convenience. It's saying you literally must have territorial jurisdiction. If you don't, then you don't have jurisdiction. What does jurisdiction mean? The power of the court to adjudicate cases or issue orders. You don't have the power to adjudicate this case or to issue orders surrounding this case if you do not have territorial jurisdiction. That's why they use the term territorial jurisdiction and not territorial venue. Because it is a matter of jurisdiction. Now remember, this is what Boasberg said. Oh, like in Padilla, like in the Padilla case, it says, rather, the territorial jurisdiction rule is a question of proper venue, citing Kennedy concurring. Let's see what Kennedy says here. These rules, however, are not jurisdictional in the sense of limitation on subject matter jurisdiction. Right, just like Pisco and Boasberg are doing. They're taking the term subject matter jurisdiction and conflating the term jurisdiction in general. Why would you need, isn't it obvious to everyone, the mere fact that subject matter is explaining the type of jurisdiction implies there are other types of jurisdiction. If there's only one type of jurisdiction and it's subject matter jurisdiction, then why would you need to call it subject matter jurisdiction? You would just call it jurisdiction. We know that there is territorial jurisdiction. We know that there's personal jurisdiction. There, I messaged Pisco, said, why don't you come on and discuss this now? These rules, however, are not jurisdictional in the sense of a limitation on subject matter jurisdiction. Let me repeat for the 50 millionth time. This entire argument started when I said, the court said it was obvious Boasberg didn't have jurisdiction. And Pisco says, no, that's not what the court said. They didn't say he doesn't have subject matter jurisdiction. Let me repeat. I said, the client's been thinking, now he has a pattern of claiming jurisdiction, Boasberg, when he blatantly didn't have it. And Pisco interrupts me and says, so he absolutely had subject matter jurisdiction. He didn't have venue. He had jurisdiction, and the courts confirmed this. He said repeatedly on X, when I said, did he have jurisdiction? Yes, or the courts didn't say he didn't have jurisdiction. Kennedy continues. These rules, however, are not jurisdictional in the sense of limitation of subject matter jurisdiction. Okay, cool. It's jurisdictional in the sense of personal jurisdiction and territorial jurisdiction, but not subject matter jurisdiction. Great. It's a good thing I never claimed that. That much is clear from the many cases in which petitions had been heard on the merits despite their non-compliance with either one or both of the rules. In my view, the question of whether proper location for a habeas petition is best understood as a question of personal jurisdiction or venue. This view is more in keeping with the opinion in Braden, and it's a discussion explaining the rules for proper form for habeas petitions, indicating that the analysis is guided by traditional venue considerations and traditional principles of venue. Even in this sentence, he says it's a question of personal jurisdiction or venue. What is personal jurisdiction? The power the court has to make a decision over an individual. The court usually for personal jurisdiction has to show that there's some sort of locational geographical element. They have the court in question has territorial jurisdiction over you in order to have personal jurisdiction. So even here, Kennedy's saying, matter of personal jurisdiction or venue. Venue being part of the territorial jurisdiction. Again, jurisdiction. He says, suggesting that the territorial jurisdiction rule is a venue rule. It can be a venue rule, but that still would mean if it's territorial jurisdiction and that's a venue rule, that doesn't mean that the venue rule is not a jurisdictional rule, a territorial jurisdiction rule. And the immediate custodian rule, which he admits that he agrees with, the immediate custodian, it must be thought of as immediate custodian, is a personal jurisdiction rule. Now think about this for a second. Kennedy is saying here, look, there are two parts of this. The territorial jurisdiction part is which venue it should be. That doesn't mean that the venue, saying that the venue is improper means that it's not jurisdiction, quite to the contrary. Territorial jurisdiction saying which court it should be held in. There are times when venue isn't territorial jurisdiction. He's saying here it is. The territorial jurisdiction is venue in this case, i.e. it is jurisdictional. But he's also saying the immediate custodian rule, the rule in which he's concurring with this decision, said, quote, for habeas petitions, jurisdiction lies in only one district, the district of confinement. Kennedy, who Pisco and Boasberg are citing here, says the immediate custodian rule, i.e. the rule that they're citing that he's concurring with, that says that habeas can only be brought amongst the immediate custodian, is personal jurisdiction. Now, nowhere in this concurrence does Kennedy say, I disagree with the immediate custodian rule. He agrees with the immediate custodian rule. And he's saying here, the immediate custodian rule is a personal jurisdiction rule, i.e., you can't file somewhere that's not the area of confinement, the district of confinement. If you do, there's no personal jurisdiction. If a court doesn't have personal jurisdiction, do they have jurisdiction to adjudicate and to issue orders? No. Now, just to be clear, Pisco says he could do tomorrow. I'm not sure what I have planned tomorrow, but if I could stream, I'll talk to him tomorrow about this. No problem. But notice that his supporters say I ran from him when he said, I'm streaming. You want to come on? I offered to talk to him yesterday. His schedule was such that he couldn't do it. Fine, no problem. I offered to talk to him today. He says, I can't do it today, or he implies he can't do it today. How about tomorrow? Now, why is it to Pisco supporters I'm running when I can't stay up until 11 o'clock at night when he's starting a stream and then wait for him to say everything he wants to his audience and then jump on the stream? I'm not saying he's running. He may very well be busy. Believe it or not, people do have, things come up. People. Now, continuing. So, again, I don't understand how Pisco could read this. The immediate custodian rule, which Kennedy is on top of this decision for, he's concurring with the decision. He doesn't disagree with the immediate custodian rule. He says is a personal jurisdiction rule. The only thing he's saying is, Kennedy's saying here is, whoa, let's hold our horses. This isn't saying that they don't have subject matter jurisdiction. This is more of a question of territorial jurisdiction and personal jurisdiction. They don't have that. They don't have the territorial jurisdiction. They don't have the personal jurisdiction. But let's not go too far and say they don't have subject matter jurisdiction. That's all Kennedy's saying here. That's it. And Pisco goes, aha, that proves that the court the court had jurisdiction. No, it proves that the court may have had subject matter jurisdiction, but the Supreme Court said they didn't have personal jurisdiction or territorial jurisdiction. That's why jurisdiction was only in the district where the confinement takes place. Again, this is black and white, the letters that they use. For habeas petitions, jurisdiction lies only in one district, not venue. It doesn't say the venue can only be in one district. It says the jurisdiction is only in one district, the district of confinement. Therefore, if a court that is not the district of confinement wants to weigh in, they do not have jurisdiction. The jurisdiction is only in one district court. The district of confinement. Now, it would have been easy to say, yeah, I guess Rob's right. Okay, fine, whatever. But he can't. He has to keep doubling down, stream after stream. Rob's a fucking idiot. Oh, I've blown the fuck out, dipshit. Now, I can tell you what Pisco is going to say. He's going to come on and he's going to go, whoa, jurisdiction. When lawyers use jurisdiction, this is what they mean. Because I'll say, okay, you have to walk through him like a child, because he wanted to make this semantic argument. That's what he wanted to do. He wanted to make this about semantics. Actually, Rob, no, the court, you're wrong. The court didn't say he didn't have jurisdiction. He has subject matter jurisdiction, and so therefore he has jurisdiction and blah, 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 blah. Like, there's diversity jurisdiction and there's personal jurisdiction, and like, you're not even a lawyer. You don't understand this. Like, you don't know what the hell you're talking about. Don't tell me about the law. I'm a lawyer. Cool. Supreme Court literally quotes saying, when it comes to habeas, this particular case, they said only due process that they're entitled to there is habeas. And because of that, only one district has jurisdiction, the district of confinement. Is Boasberg the district of confinement? No. Therefore, that's right. He's trying to conflate venue and personal jurisdiction. I don't understand. You can't make this more black and white. Let me get a pencil. Maybe a syllogism's in order. I don't have to write it up. 1, only the district of confinement has jurisdiction. 2, Boasberg is not a judge in the district of confinement. Therefore, let's repeat that. 1, only the district of confinement has jurisdiction. 2, Boasberg is not in the district of confinement. Therefore, jurisdiction lies in only one district, the district of confinement. Boasberg is not in that one district, the district of confinement. Therefore, jurisdiction does not lie there. He does not have jurisdiction. This is from the Supreme Court's own ruling. When Pisco's like, yes, but go back, they cite this Padilla case, and go back to that and read Kennedy's concurrence. Nowhere in Kennedy's concurrence does he say he doesn't believe in the immediate custodian rule. Let's keep reading it. This approach is consistent with the reference to the respective jurisdictions. We read this. The phrase respective jurisdictions does establish a territorial restriction on the proper forum for habeas petitions, but does not necessity establish that the limitation goes to the power of the court to hear the case. Because the immediate custodian and territorial jurisdiction rules are like personal jurisdiction or venue rules, objections to filing of petitions based on those grounds could be waived by the government. In other words, the government, the DOJ, could say, you know what? We'll allow the writ of habeas and sort of decisions based on that to be in any district, because the government's the defendant here. And when it comes to personal jurisdiction, defendants could waive that. For example, if I have some sort of civil case in Pennsylvania and everything occurred in Pennsylvania, but conservative carnage sues me in California, I could waive and say, okay, I'll accept the court's ruling in California. But that, if I don't waive, so in the same sense here, the government could waive and say, yes, we acknowledge, we'll allow Boasberg to have jurisdiction over this. But if they don't waive, then he doesn't have jurisdiction. He continues, the fact that no respondent was ever served with the process or appeared in the proceedings is not important. The United States resists the issuance of writ. A cause exists in that state of proceeding, and appeal lies from denial of writ without the appearance of the respondent. For the same reason, the immediate custodian and territorial rules are subject to exceptions, as acknowledged in the court's opinion. This does not mean that habeas petitions are governed by venue rules or venue considerations that apply to other sorts of civil lawsuits. Although habeas actions are civil cases, they are not automatically subject to all federal rules of civil procedure. These rules are applicable to proceedings for habeas corpus to the extent that the practice in such proceeding is not set forth in the United States rules governing. Instead, these forum location rules for habeas petitions are based on the habeas statutes and the cases interpreting them. Furthermore, that the fact that these habeas rules are subject to exceptions does not mean that, in the exceptional case, a petition may be properly filed in any one of the federal district courts. When an exemption applies, courts must still take into account the considerations that in the ordinary case are served by the immediate custodian rule, and in a similar fashion, limit the available forum to one with the most immediate connection to the named custodian. Again, when we're talking about questions of jurisdiction, Jack of Trades, thanks so much for $10, says personal jurisdiction. Yeah. So what it's saying here is like, look, habeas is different. It doesn't, like, there's exceptions because habeas is different. But even still, the personal confinement rule, which Kennedy is agreeing with, says you still, even if it's exceptional cases, you have to limit which court has jurisdiction, which case is allowed to weigh in on this, which cases a court is allowed to adjudicate and issue orders of, to the district of confinement, even in exceptional cases. I would not decide whether these habeas rules function more like rules of personal jurisdiction or rules of venue. He's not taking a stance on if it's personal jurisdiction or venue. Again, so the idea that Boasberg and Pisco are both saying, oh, it's all venue. I can't stress how important that sentence is, because previously you could see, I said, he's saying it's either personal jurisdiction or venue. Well, if it's personal jurisdiction, Pisco's lost the argument. But he's going to say it's venue. And yet, they're citing Kennedy as like definitive on this. Kennedy specifically says, I'm not saying whether it's personal jurisdiction or venue. It's difficult to describe the precise nature of these restrictions on the filing of habeas petition, as an examination of the court's own opinion makes this clear. The precise question of how to best characterize the statutory direction respecting where the action must be filed need not be resolved with finality in this case. Here, there has been no waiver by the government. There is no established exception to make to the immediate custodian rule or the rule that the action must be brought in the district court with the authority over the territory in question. And there's no need to consider some further exception to protect the integrity of the writ or the rights of the person disdained. For the purposes of this case, it is enough to note that even under the most permissive interpretation of the habeas statute as a venue provision, so even if we say, okay, it's just venue, it's not personal jurisdiction, the Southern District of New York was not the proper place for this petition. As the court concludes, in the ordinary case of a single physical custody within the borders of the United States, where the objection has not been waived by the government, the immediate custodian and territorial jurisdiction rules must apply. Again, what rule must apply? Territorial jurisdiction. Pisco is in the unenviable position of arguing that territorial jurisdiction rules that must apply aren't jurisdiction rules. Again, he's citing the Kennedy concurrence. Kennedy's saying territorial jurisdiction rules must apply. And those rules say it has to be the area of confinement. And Pisco's saying, but that's not jurisdiction. Territorial jurisdiction isn't jurisdiction. Can I make it any more clear than this? I also agree with the arguments from the statutory text and case law that the court martials in support of these two rules. Only in an exceptional case may the court deviate from these basic rules to hear a habeas petition filed against some person other than the immediate custodian of the prisoner, or in some court other than the one whose territory custodian may be found. Even then, this case isn't the exception, so that wouldn't apply here. The court has made exceptions in cases of non-physical custody. That doesn't apply here. And the removal of a prisoner from the territory of a district after the petition's been filed doesn't apply here. In addition, I would acknowledge that an exception, if there's an indication the government's purpose in removing the prisoner to make it more difficult for his lawyer to know where the habeas petition should be filed, or where the government was not forthcoming with respect to the identity of the custodian and place of detention. In cases of that sort, habeas jurisdiction would be in the district court from whose the territory the petitioner had been removed. In other words, if you took these Trans-Daragawa people from Denver, then the district court of Denver would be the appropriate place. Not Boasberg, not in D.C. But that's not what we're talking about here. In cases of that sort, in this case, the government had removed Padilla from Southern District of New York, but refused to tell his lawyer where he'd been taken. The district court would have had jurisdiction over the petition. Or if the government did inform the lawyer where the prisoner was being taken, but kept moving him so a filing could not catch up with the prisoner, that'd be different. None of the exceptions apply here. There's no indication the government refused to tell Padilla's lawyer where he'd been taken. The original petition demonstrates the lawyer knew where Padilla was being held at the time. In these circumstances, basic rules apply, and the District of South Carolina was the proper forum. Both Padilla's change in location and the change in custodian reflected a change in the government's rationale for detaining him. He ceased to be held under the authority of the criminal justice system and began to be held under the military detention system. Rather than being designed to play games with form, the government's removal of Padilla reflected the change in that theory. The change in custody and the underlying change in rationale should be challenged in the place that the government has brought them to bear against the person who is the immediate representative of the military authority. That place is the District of South Carolina, and that person is Commander Marr. The Second Circuit erred in holding the Southern District of New York was proper form. As the court concludes, I'm going back to just this line. As the court concludes, in the ordinary case of a single physical custody with the borders of the United States, where objections not been waived, the immediate custodian and territorial jurisdiction rules must apply. Remember, he says the immediate custodian rule is a personal jurisdiction rule. Jurisdiction. Immediate custodian is personal jurisdiction. Territorial jurisdiction applies, he says. Now, I'm going to bring Pisco on, and he's going to say, well, let me explain, you dipshit. You fucking idiot. You blown the fuck out and cope. You fucking idiot. Fucking hell. Let me explain. So there's jurisdiction involved, that's subject matter. They never said they didn't have subject matter jurisdiction. It's clear that that's what we're talking about. We talk about these things, subject matter jurisdiction. There's diversity jurisdiction and personal jurisdiction and all these other types of jurisdiction. For example, if you had some sort of civil case that was being held, in other cases, we could see in the Padilla case when it said with the concurrence of Kennedy, you could see that they said these sort of things where you'd vis-a-vis be able to have the sort of jurisdiction that they're talking about there, right? But these are questions of venue, which is different, and because you can see that venue is different in jurisdiction, and you're such a stupid fuckhead that think that venue just means jurisdiction, when that's clearly not the case. So it's clear that the court said that there wasn't subject matter jurisdiction, which shows that they never said that there wasn't jurisdiction there, and it's clear it's just a case of venue, which is different than the case of jurisdictions, how all of us refer to it. That's what Pisco is going to say. That's what he's going to say tomorrow. He's going to just ramble on, and he's going to try to bullshit you that territorial jurisdiction isn't jurisdiction, that personal jurisdiction isn't jurisdiction, that when the Supreme Court says for habeas petitions, jurisdiction is only in one district, the district of confinement, he's going to have you believe, but that's not about jurisdiction. That's about venue. That's what he's going to do. What's up, cool? Cool VIC or V1C? Cool Vic, I guess. I appreciate the videos you did on me. Thanks, man. That's what he's going to do tomorrow. Then he's going to do the exact same thing he accused me of. He's going to mind read. I know what you meant. I know what you meant. What you meant was subject matter jurisdiction. You're trying to say that the courts have no right to rule over the executive and blah, 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 blah. That's what he's going to do. He read this. And here's another thing that's great. He read these documents to his audience. He read them to his audience. And his audience is like, yeah, wow, blew Rob up. Clearly, the court said he had jurisdiction. They didn't say he didn't have jurisdiction. Clearly, when the court said only one district has jurisdiction, the district of confinement, and that's not Boasberg, clearly that wasn't them saying he didn't have jurisdiction. Territorial jurisdiction is a court's authority to preside over legal proceedings in a geographical area. Their authority. What's jurisdiction? The power or the authority of a court to adjudicate cases or issue orders. In other words, if they don't have territorial jurisdiction, they don't have the authority to preside over legal proceedings in a geographical area. I look forward to talking to Pisco about this. I wish he would have came on tonight. He has other priorities, no problem. By the way, look at this. Isn't this funny? Here's this guy quit simping. Notice how when I asked Pisco, do you want to talk yesterday? He said, we'll be reviewing your stream, Rob, and providing the critical analysis it deserves and blowing you the hell out for your ignorance. And then happy to have you on. No thanks. See, quit simping's like, see, Rob didn't want to debate. He didn't want to debate, see? What he leaves out is I said, no thanks. I can't do it. He just screenshots and clips out. Is that nice? Here, let's see what I actually said. Here's what this guy says I'd said. No thanks. Here's what I actually said. No thanks, won't be around. Happy to talk to you now if you like. He literally, in the middle of the sentence, blacked out what the rest of what I said in the sentence. You see what he did there? You see? This quit simping guy, ironically named, when I posted today, hey, I'll be streaming late. I'm shopping for lawnmowers with my family. He was like, you still live with your parents? No, I said I was shopping with my family, like my wife and son. Am I to believe the implication of that is he thinks that family only means your parents? Probably because he doesn't have a family of like someone that he's married or children of his own. And now he says the reason Pisco can't join tonight is, quote, Pisco has a job. Rob lives in his parents' basement rent free. There's a huge difference. I don't live with my parents. I don't feel the need to black out people's mid sentence, their comments, to try to simp. And his name's Quit Simpin'. Quite ironic. So we'll see. I don't know what my schedule is so far for tomorrow. My brother's like, I currently am living in my parents' basement, so Rob's not here. So I don't see. I don't quite think there will be any conflict. I'll be able to talk to Pisco tomorrow night as long as he can call in around the times that I'm streaming. But it should be fine. As far as I know, my Thursday night's available. So be happy to do it. And it's going to be word salad bullshit, where Pisco's going to explain to you how personal jurisdiction and territorial jurisdiction, from sources that he cited, aren't jurisdiction. Nope, those aren't jurisdiction. And he's going to go on and on and on and on and bloviate. First question I'm going to ask, Pisco, if you're watching to prepare if I could debate tomorrow, I can't confirm it. I have to check with my wife. Once I check with my wife and see what our schedule is tomorrow, then I'll be able to decide whether or not. I'll say, can you define jurisdiction? That'll be my first question. And my second question is going to be, if jurisdiction lies only in one district, does that mean that districts outside of it don't have jurisdiction? That's going to be my second question. Then my third question is going to be, is personal jurisdiction jurisdiction? If you lack personal jurisdiction, do you lack jurisdiction? Then my fourth question is going to be, if you lack territorial jurisdiction, do you lack jurisdiction? That's it. It will take him probably 25 minutes to answer those questions. Well, HN, I don't think that that's quite what Andrew Wilson would think, but even if it was, I don't care. I think for myself. That's it. And he's going to go on and on. And he'll say, do you disavow? Yes or no? Answer this question, yes or no? Answer yes or no right now. Answer this question, yes or no right now. That's what he'll do. And he'll try to obfuscate. That's it. That's the 4 questions I have for him. Then we could go from there. Do you admit that Kennedy in the concurrence that both you and Boasberg are relying on says the immediate confinement rule, he supports it? He agrees with that. Do you also admit that he says that that is a personal jurisdiction rule? So it should be fun. Now, I enjoyed this stream thoroughly. We'll do one more of this shit with Pisco on this jurisdiction stuff, whether that's tomorrow or a day in the future. We'll do one more, and then I'm going to move on to bigger and better things. But the reason I think this is worth talking about, this was a semantic argument that Pisco made to sort of deflect from the general when I said Boasberg clearly didn't have jurisdiction. Yes, he did. The court didn't say that. They didn't say he doesn't have subject matter jurisdiction. Yeah, I never said that. But the reason it's important is to give you an insight into how people like Pisco debate. That's what's going on. He tried to, and remember, 95% of my conversations with Pisco have to do with legal matters. He's a lawyer, and he's right to make fun of me. You're right. I didn't discuss Padilla in law school. I do home health care, making shit money, a job that I could have with my GED. You're right. I didn't go to law school. So how embarrassing for you to argue semantics and still keep doubling down and being this wrong. How embarrassing. Oh yeah, I didn't know that you weren't a mod. How do I do that? I don't know. I'll EOD. Yeah, well, let me figure it out somehow. If you're a mod EOD and you could set up to raid people, I would love that. I don't know if mods have that authority, but I can't figure the damn thing out to save my life. People have talked me through it. Okay, EOD. Add moderator. There you go. Yeah, EOD, I'll reach out to you. Maybe we'll set that up. I got to make sure that that's cool with Black Elk too, though, because he's the editor. And so, all right. I hope you enjoyed this. I wish that someone from Pisco's audience, I wish there were people here that could see how they think he BTFO'd me, and it's a joke. He relies on these sort of legalese and semantics, and he's wrong even about those. He's wrong. The very documents that he said, he keeps saying, Rob's citing these very documents. Yes! And they're talking about how this is matters of territorial jurisdiction and personal jurisdiction. And any court not in the area of confinement doesn't have jurisdiction. Well, that's habeas is unique. It's not the way the terms are. Nonetheless, this specific case is about jurisdiction. So when referencing this specific case, we should prefer the specificity, even if he was right. That in all other cases not regarding habeas, that this sort of discussion of territorial jurisdiction, personal jurisdiction, etc., wouldn't be what normally would. Even if that was true, which I'm not conceding it is, but even if it was true, what does it matter? We're not talking about all those other cases. We're talking about whether or not Boasberg had jurisdiction in this case that said habeas is the remedy. And for Pisco to go, well, it's a good thing that I brought it up because it allowed to this further in-depth discussion. No, what it showed was just the sort of type of bad faith person you are. You appeal to this position of authority. Then when someone scratches the surface and it's like, wait a minute, let me look this up real quick on the computer. It turns out you're full of it and you're wrong. You tried to sort of deflect to sort of this ridiculous semantic argument, and then you were wrong about it. That's what happened. So, right, jurisdiction is always the first question. For this action, for these parties in this place, does the court have jurisdiction? Right. So, all right. Hopefully, we'll see you all tomorrow night around 7 or 8. That's the plan. Talk to the fam and see what's going on, but I think that's the plan. Great. I enjoyed the show thoroughly tonight. Thank you to everyone that donated to me. I appreciate it. The donations that have came in recently, I really appreciate it. Helped me get my 0-turn mower today. So I had fun mowing today with my new lawnmower. That was a lot of fun. And hopefully I'll have many, many more days of mowing my yard. I got to do the push mowing tomorrow, though, in my yard. So push mowing sucks, but I'll get it done. It won't be that bad. Probably only 10, 15 minutes worth to do. Probably half hour to do, but nonetheless. But yeah. Maybe I'll be talking to Pisco tomorrow. It'll be fun. So thank you so much, everyone. I really appreciate it. We'll probably see you all tomorrow. As always, have a good one.